So jury selection in the YSL RICO trial began this morning, and so I wanted to fill you guys in on what goes on in that process. So let's get to it. My name is Jamahl Kersey. I'm the principal attorney at Kersey Law, a boutique criminal defense firm in San Diego, California. And in this video, we're giving you some insight on the jury selection process. Trials are published everywhere. You see them on the news, on social media. You'll see, usually opening statement, direct and cross-examination of witnesses. You'll see closing arguments. But jury selection is something that you don't see because even when a case is televised, the jury selection process never is. So cameras are never allowed in the courtroom during the jury selection process. Realistically, if you've never actually been through a trial, then you would never actually know how you end up with those 12 members who ultimately end up in the jury box. So I want to give you some insight on that. So jury selection is also known as what's called voir dire, and voir dire means that which is true. It's a very, very, very important aspect of trial. As a defense attorney, if you mistakenly leave certain people on the jury, such as people who are going to have an unfair bias against your client, or for whatever reason they're going to be unfair against your case, then your case could be lost before even one piece of evidence or even one witness is called to testify. And so jury selection is actually the process through which the prosecutor and the defense select the jurors who are going to hear the case. And, it might actually be better put to call it jury deselection because it is the process of removing one by one the prospective jurors until you end up with the 12 that are ultimately going to be on the jury panel. You want a jury that's going to be fair and impartial, and ultimately this is what both sides want. So both the prosecution and the defense want to make sure they end up with a jury that can be fair and impartial. You start with a room full of jurors. So if you've been in a courtroom, the gallery where the audience usually sits, that's where the prospective jurors will be. And so it's going to be a room full of people. If it's a more serious case, you might even have up to 100 people in that gallery waiting to see if they're going to be selected for the jury. One of the first things that the judge is going to do is announce the parties. He's going to announce the parties, the lawyers, read off a witness list. They want to make sure that none of the prospective jurors have any ties to any witnesses or parties to the case. You wouldn't want to have a situation where you have Deputy Johnson who's going to take the stand, and Deputy Johnson's credibility is at issue, and then you end up in the jury room only to have somebody say, hey, I've known Deputy Johnson for 20 years. He'd never lie about what it is that he saw. If you have that happen, you can see how problematic that could potentially be. So the judge wants to make sure that there are no people who have any personal connection or ties to the parties of the case. The judge is also going to read off the charges. So these prospective jurors are going to be made aware of what the charges are against the defendants. The judge will also read a paragraph that's a synopsis of the case. So they're going to get the basic facts and allegations of the case. And this is going to be very important, and I'll tell you why in just a bit. Next, typically the judge is going to hand out a questionnaire, and the questionnaire is designed to elicit information that's ultimately going to help the lawyers in picking the jury. So the questionnaire asks questions such as, what is your occupation? What is your marital status? Do you have any children? Are you in law enforcement? Do you have any loved ones or close family in law enforcement? Have you ever been a victim of a crime? Have you ever sat on a jury? Did you reach a verdict? And ultimately, is there any reason why you cannot be a fair and impartial juror in this case? And this is a very personal process. You can only see by the questions that I just asked, it does ask for very intimate information. So during jury selection, people are going to be saying things that they would never tell a stranger, and certainly not a whole room full of strangers, 40, 50 people in a room hearing about details of your life, but that's actually what happens during jury selection. Again, this is where that reading of the allegations is really important. Some people, just in hearing the basic allegations, simply cannot be fair and impartial. Just for an example, if my client is being charged with a DUI, so just a straight DUI, no accident, no injuries. He's alleged to have had one too many drinks after a party. He was speeding, he got pulled over, and then that led to him being arrested for a DUI. If we're going to trial on that case and there's a prospective juror who actually lost their daughter because a drunk driver had plowed through a red light, smashed into her vehicle, killing her on their graduation night, there's going to be the type of person who probably cannot be fair and impartial. And when they answer that last question of, is there any reason why you can't be fair and impartial? Then they're going to say, listen, no, I cannot. And the judge will usually ask, you said you can't be a fair and impartial juror. Can you tell us why? And then that's when they're going to say, unfortunately, 10 years ago, my daughter was killed by a drunk driver on the night of her graduation. Just even hearing about somebody driving under the influence of alcohol is just too much for me. I know I can't be fair and impartial. And you really appreciate that level of honesty, because you can see why you would never want to have somebody like that on your jury, because just hearing the evidence is going to be too triggering for them. But that's not always the case. Just because someone or their family may have been a victim of the same, facts or circumstances relating to the case, that doesn't necessarily mean that they can't be a fair and impartial juror. For example, you may have a person who their father died due to a drug overdose, right? And if your client is being charged with selling cocaine, then, naturally it's going to be a concern. So you might think that someone who lost their father due to their drug addiction, maybe they can't be fair and impartial, but it's possible that they could. Because when the judge asks, is there any reason why you can't be fair and impartial? They might initially say, hey, my father died due to a drug overdose. I understand that he had addiction issues. That was his problem. And I still believe that I can sit through the evidence, I can keep an open mind, and I can be fair and impartial. And you're analyzing their sincerity, their body language. And if you think that it's not going to be an issue and they otherwise would seem like a good juror, then that might not be someone you ask to be kicked from the jury. And so based on the responses to the questionnaire, there are going to be a few prospective jurors who are actually removed for cause. And what being removed for cause means that there are people who just are simply incapable of being fair and impartial, and so therefore they should be removed. The defendant has a right to be tried by a jury of his peers, but as part of this process, we need individual jurors who can be fair and impartial, listen to the evidence with an open mind, and are not going to be swayed by information that they should not be swayed by. So through that questionnaire process, there are going to be some people that are ultimately removed because they just can't be fair and impartial, or they otherwise don't belong on the jury. That's just going to be a few people. So then when you have the rest of the people still remaining in the gallery, the lawyers then will have the opportunity to ask specific questions to the prospective jurors. Each side, both the defense and the prosecution, gets around 20 to 30 minutes to ask their questions. Some judges are super strict and will only give you around 10 minutes. It just really depends. So that's definitely something that you want to know going into it, because you don't want to have a 20 or 30 minute voir dire prepared only to find out that the judge is only going to give you 10 minutes. That could be really problematic for you. And you have to be very strategic about your questions that you ask, because the process goes really fast. There are certain issues that you want to focus on in voir dire, because you can almost ask whatever you want. Obviously, there are boundaries, but you have free reign to ask the questions that you want to ask. So you really have to be strategic about it in order to ultimately expose the thoughts, the biases, the beliefs that could make somebody a bad juror for your client. So going into some of the specific issues that we on the defense side go into during voir dire, using this YSL case as an example, I would definitely want to touch on the topic of gangs. I want to know, does someone have just a serious problem with gang members in general, or those accused of being gang members, such that they can't give my client a fair trial? We know that that's one of the issues in this case, whether YSL is a business organization, a gang, or both. There are going to be people who find gang members to be the scum of the earth, and I need to know that. If that's going to be something that's going to unfairly prejudice my client and they can't view the evidence objectively, then we need to know that. Let's just say a local gang shot up a park and your cousin caught a bullet in the head. That can affect the way that you look at the evidence. If you're going to put everybody in a box and just assume that because police testify that my client is a gang member and he may not be, I want to make sure that you're not being unfairly prejudicial against my client. One of the other issues when you have a case like this is going to be violence. There was allegations of an attempted murder as it related to YFN Lucci, and there was the actual murder of Mr. Thomas. So we know that there's an allegation that Young Thug had rented the automobile that was used involved in the drive-by shooting of Mr. Thomas. We want to know, if you hear testimony about violence, you hear about someone getting shot, you hear about someone getting stabbed. Are you so sensitive that you're just going to see red and you can't objectively look at this evidence? If that's going to be too much for you and you can't keep an open mind, then I don't want you on my jury. The other issue might be drugs. So we talked about the father who had died of an overdose. But there are some people who are just vehemently against drugs. No matter what, they might not even like prescription pills, but they just hear anything about drugs and they flip out. They just can't stand any talk about drugs. It's a gateway to committing sins. Taking drugs itself is a sin. If they're going to be overly judgmental and critical about drugs, whether that's using them, selling them, then I don't want that kind of person on my jury. Keep in mind, let's be realistic here. We're not looking for people who are pro-crime or pro-gangs, pro-drugs. I mean, that's just not going to happen anyway. We just don't want somebody who's going to be unfairly biased against our client, such they can't be fair and impartial and give our client a fair trial. One of the other issues that's really important is I want to make sure that a person is very interested in the process. This might be the subject of direct questions to prospective jurors, but I'm looking at people's body language. I'm looking at how engaged they are. I'm listening at how they answer questions. If I see somebody who just doesn't seem to want to be there, they're the kind of person who's going to be falling asleep during crucial pieces of testimony, I need them to be hanging on every single word. I need them to be able to see the different nuances. I need them to be engaged during the trial, taking notes, actively listening. So if I have somebody who gives me doubt as to whether they're going to really take this process seriously, then they got to go as well. One of the other things that defense attorneys definitely do is we emphasize reasonable doubt. At the end of the day, the judge is going to give an instruction on reasonable doubt and what it means and how it applies, but I want to hit it from the start in jury selection. I want to make sure that they know from the jump that I don't have the burden of proving anything. My client doesn't have the burden of proving anything. It is only the prosecutor. It's the prosecutor who has the burden of proving guilt beyond a reasonable doubt. To illustrate that point, I can say, hey, I could sit down in my chair for the rest of the trial and not say anything. If the prosecutor still hasn't proved their case beyond a reasonable doubt, you have to find my client not guilty. And, obviously I'm not just going to sit down and say nothing, but that is very illustrative of the point. They have to understand where the burden lies, and it's solely with the prosecution. Another thing we as defense attorneys discuss in voir dire is the presumption of innocence. I want to see if people understand what the presumption of innocence is and how they feel about it. If you have someone who isn't willing to accept my client is presumed innocent unless and until he's proven guilty, then that could lead to me wanting to have him kicked. But it also could lead to a possibility of educating or rehabilitating a prospective juror. So just because they give you an answer that you don't like doesn't mean that you're automatically going to try and have them kicked off the jury. Sometimes a person can say something and you can use what you perceive as a bad answer as an opportunity to educate that person, rehabilitate that person, and now you're drawing up more credibility from the jury, and that gives you an opportunity to see whether people agree with the newfound premise that you've established through your questions. Along the lines of the presumption of innocence, one of the things we have to address is the common thought that the defendant has to have done something. So if the government has gone this far to put this case in front of a jury, they have to have done something, right? And the answer is no, that's not the case. Police only need probable cause in order to arrest somebody. The police don't need to find somebody guilty beyond a reasonable doubt in order to arrest somebody. In fact, that's what the jury's job is to do. It's the jury's job to determine whether or not there's guilt beyond a reasonable doubt. Just because the police arrest somebody, it doesn't mean that a person is guilty. There are oftentimes situations where a person gets arrested and they never even get charged with a crime. Or sometimes people get arrested, they get charged with a crime, and that case gets dismissed. Or people get arrested, get charged with a crime, go to a trial, and they get acquitted. So that just goes to show that not everybody that gets arrested for a certain reason is inherently guilty. So it's very important that we emphasize and that jurors understand that just because someone gets arrested and the DA makes a decision to file charges against them, it doesn't mean that that person is guilty. Again, it's for the jury and the jury alone to ultimately make that determination. So by the time jury selection comes around, the defense team may already know whether or not the defendant is going to take the stand, but sometimes you don't know. It could be a mid-game decision that you decide to put your client on the stand. If there's any chance that your client is not going to take the stand, then that's another issue that you're going to want to address. The judge is going to issue an instruction to the jury letting them know that the defendant has the right to remain silent and he cannot be compelled to testify, and that furthermore, they can't hold it against him if he decides not to testify. But I still want to make sure that the point is driven home that they cannot hold it against the client if he doesn't take the stand. So this comes up every time during voir dire because it's natural for a person to feel like if they were charged with a crime, that they would want to take the stand and clear their name and say their piece. But the Fifth Amendment, again, it protects us from self-incrimination, including at trial. If a person feels like, hey, I would want to take the stand, you definitely want to address that and have them acknowledge that, hey, okay, we understand that that's something that you would do, but if my client decides that he's not going to take the stand, you will not unfairly hold that against them. If you get anything other than a resounding yes in response to whether they can be fair and impartial and they're not going to hold it against your client, then that's going to be somebody that you're going to want to have kicked. Another issue is, have you worked in law enforcement or do you have any ties to law enforcement? Now, I'm not automatically going to kick somebody who has law enforcement ties, but it is going to raise a red flag. Reason being, people who are former law enforcement officers, former probation officers, or people who have close law enforcement family, they tend to be a lot more conservative. If a person is going to be very biased towards law enforcement or leaning towards things that a deputy sheriff is going to say versus one of my defense witnesses or something like that, that's not going to be somebody who I'm going to want to keep. On the flip side, for the prosecutors in this case, they definitely want to make sure that someone's not a super fan of Young Thug, right? So if you've been a fan since I came from nothing, if you've ever written hashtag free thugger in a comment section, then that's just not going to be a person that a DA wants on the jury, because there's going to be people who, no matter what evidence would be presented in front of them, their love for Young Thug or their fandom is not going to allow them to be objective. Basically, anything that's going to be presented to them, they're not going to see as pointing to guilt. So the DA would want that type of person removed. Picking a jury is definitely much more an art than a science. You're asking questions, you're observing body language when they're answering. Sometimes somebody can answer a question and they can say, yes, I can be fair, but then you look at them and their body language is closed off. They might not be looking at you in the eye. The tone of their voice might rub you the wrong way. And if you're getting this kind of vibe, then you're gonna wanna go deeper with questions, but sometimes there are people you're just like, no, I can't have them on my jury. And another aspect that is really important is my establishing, or the defense attorney establishing, their credibility. So the courtroom ultimately belongs to the judge. No one's gonna be above the judge in the courtroom, but I wanna establish my credibility too. The jury needs to see that I'm cool, I'm calm, I'm collected, I'm poised, I'm an authoritative figure, I'm likable, and they can trust me. If they don't like me and they don't trust me, it's just gonna be all the more harder when I'm standing in front of them delivering an opening statement, when I'm delivering a closing argument. I need them to buy what I'm selling. And so it's very important for me to establish from the very beginning that I am to be trusted. I'm a credible figure in the courtroom. So during this process of the questions and answers, you're taking notes on what's being answered. And once both sides have finished with their questioning, then the lawyers are going to go one by one, picking the people that they want to have removed from the jury. And what these are called are peremptory challenges. So each side will have a number of peremptory challenges where each side will have the opportunity to request that a prospective juror be removed. This process goes back and forth, so defense, prosecutor picking people to be removed until they end up with the 12 people that are going to sit on the jury, and there will be 2 to 4 alternate jurors that are selected, and that's usually going to depend on the anticipated length of the trial. And so that's the basics of jury selection from a defense perspective. This process generally is going to last a few days. In a case like this, it could last longer. Sometimes a jury selection can be weeks, just depending on the number of prospective jurors that they start with and the number of peremptory challenges, the complexity of the issues in the case, and the like. So once the jury selection process is done, the judge will issue a few more instructions and then come opening statements. So we're in jury selection now in this YSL case, and opening statements will be next. It's worth noting that Young Thug's attorney has repeated to the media yet again that Mr. Williams has committed no crime whatsoever. He'll have the opportunity to demonstrate and expose that in the weeks to come. So that's going to be the end of this video. If you got something out of this, please show me some love and hit the like button. Make sure you subscribe to the channel and turn on those notifications so you never miss a new video when it drops. As always, I want to thank you so much for watching, and until next time, peace.